Hi, I'm Nick Lee, a legal director at Rosenblatt. I'm here to talk about a fascinating area of law, one in which I have some considerable experience. It is the extent to which the court is willing to revisit decisions it would otherwise consider concluded. The finality of litigation is a long-standing tenet in the English legal system. Parties to a claim are entitled to get on with their lives once a case is concluded, which often means that a trial has taken place, all avenues of appeal have been exhausted, and a huge amount of money has been spent. There comes a point when the losing party has to accept that they've lost. They cannot be allowed to harangue their opponents forevermore, especially if they have the means to do so and their opponents do not. However, there's another long-standing tenet of English civil law, which is that the court has an equitable jurisdiction to address instances of malign behaviour, which, if it were not dealt with, would deny the correct party justice, subvert the legal system, and make fools of everyone but the fraudster. In certain circumstances, then, the need to ensure justice can cause claims that were otherwise concluded to be revisited. Such fraud can take many forms, but its aim is the same each time, which is to persuade the court to believe something which is not correct and reach a judgment it would otherwise not have made. Perhaps a party doctored a piece of evidence to make it say what they needed it to say in support of their claim. Perhaps one or more of their witnesses knowingly gave false evidence, or they persuaded others to do so on their behalf. Such tactics would not have been known to the court at the time, and the judgment that followed would therefore have been tainted with fraud. The court has for many years had the power to set aside a judgment obtained by some kind of fraudulent means, but its application was limited to instances where there was no way the claimant could have brought this issue before the court during the original proceedings, thus satisfying the 1843 Henderson v. Henderson requirement that a matter be brought before the court in its entirety at once. However, in 2019, the Supreme Court decision in Takkar v. Bracefield Properties changed that. Post-Takkar, I've been involved in a High Court proceedings to set aside judgment on the basis it was obtained by fraud. But the starting point for this webinar is, as things so often are, the Birmingham District Registry of the Chancery Division.